Sir, am I audible now?
जी बिल्कुल निधि गोयल. टेल मी समथिंग अबाउट योरसेल्फ.
Sir, I am Nidhi. I come from Haryana. I have done graduation in BA LLB from Kurukshetra University, Kurukshetra in the year 2024. After that, I have enrolled myself with the Bar Council of Punjab and Haryana in the same year. And I have also cleared the All India Bar examination, of which I got the certificate of practice in the year 2025.
चलिए ठीक है. तो ये आपका फर्स्ट अटेम्प्ट है.
No, sir, this is not my first attempt. But in Gujarat Judiciary, this was my first attempt.
ठीक है. ओके. निधि, आप हमें बताइए कि गुजरात जुडिशरी के अंदर जो आपने एग्जाम दिया है, टोटल कितने सब्जेक्ट्स थे इस एग्जाम को क्लियर करने के लिए? क्या कितने सब्जेक्ट्स हैं?
25.
25 सब्जेक्ट्स हैं. इसमें कुछ माइनर लॉज भी हैं क्या, स्पेसिफिकली रिलेटेड टू गुजरात?
Yes, sir.
प्लीज बताएं.
The one is Gujarat Prohibition Act,
ओके.
other is Gujarat Gambling Act,
आपको ईयर्स
and
याद है
third
इनके?
one, no, sir. For Gujarat Gambling Act, it is 1989.
ठीक है.
But sorry, Gujarat Prohibition Act, it is 1989. But Gujarat Gambling Act and Gujarat Court Fees Act, I don't know the years.
1989 कि 1949?
1949, sorry.
1949. चलिए ठीक है. और गुजरात गेमिंग एक्ट और?
And I remember this much only.
चलिए ठीक है. व्हाट इज द डिफरेंस बिटवीन लिकर एंड लट्ठा अंडर गुजरात प्रोहिबिशन
Sir,
एक्ट?
sir, liquor is anything which is in the liquid form, but it is intoxicating in nature. However, latha is a spurious liquor which is unhealthy for a person and it is illegal to make that liquor.
चलिए, कोई स्पेसिफिक लीगल प्रोविजन आपको याद है?
So for Gujarat Prohibition Act,
हम्म.
no, sir.
चलिए ठीक है. नेक्स्ट क्वेश्चन पूछते हैं आपसे. एक्सप्लेन द presumption as to commission of the offense under section 103 of the गुजरात प्रोहिबिशन एक्ट. 103 गुजरात प्रोहिबिशन एक्ट के अंदर प्रिजम्पशन जो है रिलेटेड टू द कमीशन ऑफ ऑफेंस, कुछ रिकॉल कर पा रहे हो आप?
Yes, sir. Sir, in
बताइए.
that case, there is a mandatory presumption if the person is found in possession of liquor. So that it will, and if he has not taken any permissions, then it will be presumed that the person has committed the offense under this act.
ठीक है. एक क्वेश्चन और बताइए माइनर लॉ से.
Yes,
हु
sir.
इज एग्जेम्प्टेड फ्रॉम पेइंग कोर्ट फी अंडर गुजरात कोर्ट फी एक्ट? कौन कौन एग्जेम्प्टेड है कोर्ट फी देने से गुजरात कोर्ट फी एक्ट में?
Sir, in the written statement, on written statement, we don't need to file the court fees. However, if the written statement also includes a counterclaim or set off, in that case, we need to file the court fees.
कोई स्पेसिफिक प्रोविजन याद है आपको?
No, sir. For court
चलो
fees,
ठीक है.
I do not
अभी
remember.
आपने जिक्र किया सेट ऑफ और काउंटर क्लेम का.
Yes,
सीपीसी में
sir.
सेट ऑफ और काउंटर क्लेम कहाँ डिफाइंड है?
Sir, it is provided under Order 8, Rule 6.
ऑर्डर 8 रूल 6 डील्स विद
Order 8, Rule 6 deals with set off, and Order 8, Rule 6A deals with counterclaim.
काउंटर क्लेम. व्हाट इज द
Yes,
बेसिक
sir.
बेसिक डिफरेंस बिटवीन सेट ऑफ एंड काउंटर क्लेम?
Sir, in the set off, a person can only ask for that much exemption that is the other person claiming against him. And in set off, only the money matters can be settled. However, in counterclaim, a person can claim any relief against the plaintiff.
तो अकॉर्डिंग टू यू सेट ऑफ ओनली डील्स विद द मनी मैटर्स.
Yes, sir.
मनी मस्ट
Set
बी
off only the
मनी मस्ट बी असर्टेन.
monetary terms. Yes, sir. The money must be certain. If the however, the certain money should be with the person who is claiming the set off. If the plaintiff is claiming something, then his money need not to be the certain money.
Then what is the basic difference between legal set off and equitable set off?
Sir, in equitable set off, a person can ask, like a person can set off how much amount he want. Sir, can we take an example for this?
Hmm.
Suppose there are two persons. A has a liability against B for 10,000 and B has liability against A for 5,000. In this case, both the amounts can be settled against each other and the remaining amount will be paid to the person against whom the liability remains.
If the
How,
if the if the party has different character, then
sir, in that case, legal set off can't be claimed.
okay. नेक्स्ट क्वेश्चन, आप मुझे सिचुएशन बताओ जहां प्लेंटिफ प्रेजेंट है और डिफेंडेंट एब्सेंट है। आप जज होने के नाते सिविल केस में सीपीसी के अकॉर्डिंग क्या करोगे?
Sir, in that case, we can proceed with the ex parte proceedings or we can give, yes, sir.
ऑर्डर ऑर्डर
We,
एक्स पार्टी।
sir, order for this is Order 9, Rule 6.
ऑर्डर 9 रूल 6। ठीक है, फिर
Yes, sir.
डिफेंडेंट के पास कुछ रेमेडीज हैं क्या?
Yes, sir. So, defendant can file an application for the set aside of that order by showing the show cause of by showing a sufficient cause for not being present on that particular day. Also, the defendant can file an appeal against that order.
चलिए ठीक है, मान के चलिए डिफेंडेंट ने अपील फाइल कर दी,
Yes,
तो
sir.
क्या फिर वो सेट असाइड की एप्लीकेशन लगा सकता है क्या?
No, sir. Only one remedy can be claimed against it as per Order 9, Rule 13.
तो कुछ तो ऐसा सिचुएशन है कि एप्लीकेशन अपील भी फाइल कर सकते हैं और एप्लीकेशन भी लगा सकते हैं, ऐसा कुछ है ऑर्डर 9 रूल 13 में?
Yes, sir. There are certain situations in which a person can file written state. Oh, sorry. A person can file application as well as. Sorry, sir. I'm not able to recall it right now.
ठीक है, तो पहले अपील को हमें क्या करना पड़ेगा? विड्रॉ। कुछ याद आ रहा है आपको?
Okay, sir. No, sir. I'm not
चलिए
able to
ठीक है।
recall it.
अ, आप दो वर्ड हैं, एक तो है डिसमिसल, एक वर्ड है रिजेक्शन।
Yes, sir.
डिसमिसल ऑफ सूट जो है, डीम टू बी अ डिक्री और नॉट?
No, sir. Dismissal of suit does not deem to be a decree.
एंड रिटर्न ऑफ प्लेंट?
Sir, return of plaint is also not considered as a decree.
एंड रिजेक्शन ऑफ प्लेंट?
So rejection of plaint is deemed as decree as per Section 2, Subsection 2 of CPC 1908,
19 विच डील्स विद
which deals with definition of decree.
डिक्री। ओके, चलिए ठीक है। आपका कोई फेवरेट सब्जेक्ट है जिसमें आप कंफर्टेबल हैं, आपसे कुछ भी पूछें?
Yes, sir. You can ask from Contract Act.
कॉन्ट्रैक्ट एक्ट। कॉन्ट्रैक्ट एक्ट से आपसे सर पूछेंगे, उसके अलावा सेकंड फेवरेट?
The second favorite is SRA.
ठीक है, थर्ड फेवरेट?
The third favorite is Negotiable Instruments Act.
नेगोशिएबल इंस्ट्रूमेंट्स एक्ट। चलिए ठीक है, आप हमें बताइए, जो नेगोशिएबल इंस्ट्रूमेंट एक्ट है उसका
Yes,
चैप्टर
sir.
नंबर 17 ही आपके सिलेबस में है या कि पूरा एक्ट आपके सिलेबस में है?
So the whole act is in the syllabus.
चलो ठीक है, आप हमें बताओ 143 कैपिटल ए।
Yes, sir.
हाँ, आप हमें बताइए 143 कैपिटल ए में ये कौन सी ईयर में ऐड हुआ और इसको ऐड करने के पीछे लेजिस्लेचर का क्या इंटेंट था?
Sorry, sir, but I'm not able to recall this provision.
सेक्शन 148
Yes, sir. Section 148 provides rights of appeal.
एंड 143 ए आप रिकॉल नहीं कर पा रहे हैं?
Yes, sir.
चलिए ठीक, कोई बात नहीं। ये बिल ऑफ एक्सचेंज क्या होता है? व्हाट डू यू मीन बाय द टर्म बिल ऑफ एक्सचेंज?
Sir, bill of exchange means when a person who is a drawer makes an unconditional undertaking in favor of the drawee, in favor of the payee, that the draw Sorry, sir. Sir, can I repeat?
हम्म।
Sir, when a person who is a drawer makes an unconditional direction to the drawee to pay a certain amount of sum to the pay, then that instrument is referred as bill of exchange.
ठीक है, एक क्वेश्चन पूछूंगा, बहुत सोच समझ के आंसर देना। ठीक है।
Okay, sir.
Why should we hire you when there are candidates with 5 year of active legislative experience? हमारे पास बहुत सारे ऐसे कैंडिडेट्स हैं जिनके पास 5 साल या उससे ज्यादा का एक्टिव लेजिस्लेचर एक्सपीरियंस है। तो हम आपको ही क्यों लें? आपके अंदर ऐसी क्या क्वालिटीज हैं जो हमें मजबूर करे कि हम आपको अपॉइंट करें एज अ जज?
First of all, I'm a very good listener and also I had a good legal aptitude. Both are required for making good decisions. There is a possibility that the candidates who are with the 5 year of practice may be better uh, than me, then in that case, may the best person be selected. However, I also mean that mere practice cannot ensure that the person is capable of taking good decisions as well. Because pleading is one thing and taking decisions are a different thing. Though practice ensure that a person has a good command over law, but it cannot ensure that a person has capacity of taking good decisions as well.
फिर सुप्रीम कोर्ट के 3 ईयर प्रैक्टिस रूल पे फिर आप क्या कहोगे फिर?
Sir, as for me, because I have been to the courts and there I was told and also I observed that the advocates are, should I say, they are very smart. So sometimes they don't comply with the rules exactly. And when a person who just have theoretical knowledge and not very well versed with the practical exposure or who does not possess practical exposure, they actually harass that person in the manner that they does not comply with the orders properly and try to mislead the judicial officer. So I think the purpose was not to ensure the legal knowledge because that is acquired in the 5 year course as well as 3 year course, but the purpose was to understand the other side of the bench.
चलिए ठीक है, आपके पीछे एक फोटो लगा हुआ है, आप बता सकते
Yes,
हैं
sir.
कहाँ की फोटो है?
No, sir, I'm not aware.
चलिए ठीक है, मेरी तरफ से एक आखिरी सवाल। आपको 5 न्यू चेंजेस बताने हैं बीएनएसएस में जो सीआरपीसी में नहीं थे।
Sir, in BNSS, we have
बीएनएसएस।
official. Yes, sir. In BNSS, we have officially recognized the FIR, zero FIR provision. Also, now it is mandatory for the police officer to provide a free copy to the accused, victim, and informant. However, earlier such copy need to be provided to the informant only and not the victim. Also, sir, there is a provision of mercy petition which is included in the BNSS. With
मर्सी
such petition,
पिटिशन अंडर विच सेक्शन?
sir, mercy petition can be filed under section 160.
160?
Yes, sir.
आप श्योर हैं?
Yes, sir. According to me, it's 160.
चलिए ठीक है, और?
And sir, also there is a change in the proceedings regarding the complaint. And one more provision is
क्या
the
चेंज है कंप्लेंट के रिगार्डिंग?
sir, now in the complaint proceedings, a person the judicial officer has to take the evidence on record even if the case is transferred by a court or a public servant and he have to call a report from his senior in case he receive a complaint against a government official.
ठीक है, और बताएं।
Sir, also now for the further investigation, the police have to take the permission of the court after filing the charge sheet. Earlier, the police officer were free to conduct the further investigation, though there was a norm that the police officer in such cases will inform the magistrate that though he has filed the charge sheet, but he is continuing with the further investigation.
ठीक है, आप हरियाणा से हैं, तो
Yes,
हरियाणा
sir.
और पंजाब का कॉमन हाई कोर्ट है।
Yes, sir.
चलिए, कॉन्स्टिट्यूशन का कौन सा प्रोविजन है जो 2 और मोर स्टेट्स के लिए कॉमन हाई कोर्ट से डील करता है? विच ऑफ द फॉलोइंग आर्टिकल ऑफ द कौन सा आर्टिकल है कॉन्स्टिट्यूशन का?
Sorry, sir, but I'm not able to recollect this at the moment.
चलिए ठीक है, कॉन्स्टिट्यूशन के अंदर रिसेंट कोई अमेंडमेंट हुआ है?
Yes, sir, there is Amendment 106 in the Constitution.
क्या है 106?
Sorry, sir, but I'm not able to recollect.
चलिए ठीक है, कॉन्स्टिट्यूशन के अंदर टोटल अमेंडमेंट्स कितने हुए हैं?
Sir, there are 106 amendments in the Constitution till now.
ठीक है, आपको नहीं पता है 106 क्या है? 105 पता है आपको?
No, sir.
104?
No, sir.
103?
Sir, 103 was regarding the GST.
जीएसटी? ठीक
Yes,
है,
sir.
जीएसटी काउंसिल कहाँ डिफाइंड है कॉन्स्टिट्यूशन में? कोई आर्टिकल पता है आपको?
No, sir, I'm not able to recollect.
कॉन्स्टिट्यूशन के अंदर डेफिनेशंस कहीं डिफाइंड नहीं क्या? उसमें सर्विस की डेफिनेशन, गुड्स की डेफिनेशन?
No, sir.
चलिए ठीक है, और 101 क्या है फिर?
Sir, 101 regarding the EWS reservations.
ईडब्ल्यूएस 101 है आपके अकॉर्डिंग, और 103 जीएसटी है आपके अकॉर्डिंग।
Yes, sir.
आप श्योर हैं?
Yes, sir.
चलिए ठीक है, अब सर आप आगे कंटिन्यू करेंगे।
Just let me know, am I audible?
Yes, sir, you are audible.
Yes, okay. So, first of all, why do you want to become a judge?
Sir, actually, I'm inspired by my maternal uncles. Since my childhood, my maternal uncle were part of the judiciary, and through him, I got the chance to observe the other side of the bench. And also, when I show my desire to become a judicial officer, he told me that for being a judicial officer, mere knowledge of law is not enough. Rather, you need to imbibe some qualities, for instance, compassion, analytical skills, knowledge, and power of taking good decisions.
Okay, so I'll just take up some questions related to general knowledge, specifically to Gujarat. Are you aware about some general knowledge questions related to Gujarat?
Yes, sir, I am aware.
Okay, so first question will be related to that. Which river flows through Ahmedabad?
Sir, it is Narmada River.
Narmada River. Okay. What is the significance of that river? What is the importance of that river?
Sir, Narmada is considered as the lifeline of the state.
Okay. Can you tell me a UNESCO World Heritage Site in Gujarat, which is known as a stepwell?
No, sir, I'm not aware of it.
Okay. Who is the current Chief Justice of Gujarat High Court?
Sir, Honorable Justice Miss Sunita Agarwal.
Okay. Uh, See, you said your favorite subject is Indian Contract Act, right?
Yes, sir.
What is Section 28 of Indian Contract Act?
Sorry, sir, but I'm not able to recollect.
Okay. Are you aware about the Mediation Act 2023?
Sir, I'm aware of the purpose and what mediation is, but I have not gone through the act itself.
Okay. So, in Indian Contract Act itself, the Mediation Act 2023 made some changes. The amendment were made in Section 28 of Indian Contract Act. And since you're not aware of Section 28 itself, so we cannot take up that question, no issues. But can you tell me where void contract is defined in Indian Contract Act?
Yes, sir. Sir, void contract is, sir, there is, I think, no term like void contract. Whether the terminology is void agreements, which is provided in Section 2G of the Indian Contract Act. It says that when an agreement is not enforceable by law, it is void.
Okay. So you're saying that void contract is not the right term.
So,
Okay. Uh, can you define free consent?
Yes, sir. So free consent is provided under Section 14 of the Act, which provides that when the consent is taken without undue influence, fraud, misrepresentation, mistake, and coercion, then the said consent is said to be the free consent.
What is the effect of all of them?
Sir, in all of in most of them, the contract will be voidable. However, in case of mistake of fact from both the parties, the contract will be void.
Okay. From one side.
No, sir. When the mistake is bilateral in nature, then only the agreement will be void.
Okay. No, I'm asking if it is unilateral.
No, sir. It is not unilateral. In case of unilateral mistake, the contract will held to be valid.
Am I audible?
Yes, sir. You are audible.
Yes. What is the effect of unilateral mistake?
Sir, in case of unilateral mistake, the contract is valid.
The contract is valid. Okay. What do you understand by not voidable?
Sir, the not voidable also means it is valid, but it is in such case when the mistake is regarding the Indian law. In that case, in contract, it is specifically provided that when the mistake is regarding the law, then the contract will not be voidable.
Okay. So, what is the definition of offer? What do you understand by offer? I don't want to know word to word exactly, but just explain what is an offer.
Uh, For this, we can take an example. Suppose A makes an offer to B that if you want to, oh, sorry, if A makes an offer to B that will you buy my watch for rupees 100, then in such case, the A makes an offer to the B in order to receive his assent or denial to that offer which is made by him.
How many types of offers do we have?
But there is one type of offer.
How many?
So one,
One type of offer. What is that?
I didn't get the question well.
Okay. You said SRA is your favorite subject, second favorite subject, right?
Yes, sir.
So, can you tell me what was the intent behind bringing the 2018 amendment?
Yes, sir. So the purpose was that amendment to make the specific performance a mandatory relief instead of a discretionary relief.
No, that was the amendment. But what was the purpose behind that?
Sir, the purpose was to ensure that the person who has initially agreed to perform the contract cannot merely avoid his liability by paying the compensation, as the contract was done to perform a certain thing and compensation is to be given in such cases where the performance become impossible or not feasible or practicable to fulfill the contract. But people were actually taking it as an advantage and were not performing the contract. As per Anson, an acceptance to contract is like a lighted match to the train of gunpowder. So once you have agreed to a contract, you have to perform it. You cannot go back just because you want to go back or avoid the contract.
Okay, have you heard about ease of doing business index?
Yes, sir, I have heard about it.
So the purpose behind this particular amendment was that only that in India, ease of doing business index was going down. After this amendment, this
Yes,
index
sir.
was increased. The rating of India was increased, right? Ranking of India was increased. Now,
Okay,
that
sir.
brings me to another question. See, I hope you are aware about the Gujarat High Court's decision. Are you?
Sir, regarding
Recent decisions? regarding recent decisions?
Sir, I'm not aware.
Okay. So I guess that is it from my side, sir.